Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, we're here today with Charla Aldous. And Charla and I have had a difficult time crossing paths because I've invited her many times to come to Trial Lawyers University, only to suffer severe rejection. But since I don't allow that kind of rejection to hurt my feelings, then one day she texted me and said, Dan, I'd like to come to Trial Lawyers University. How did that happen, Charla?
My daughter practices law with me now, and she says, Mom, I've been listening to these podcasts from this great group called Trial Lawyers University. Have you ever heard of it? And I said, yeah, I have heard of it. She goes, do you think you would want to get involved in it? And I said, well, they've asked me to before. And she goes, have you lost your mind? Why haven't you been involved? So I'm being perfectly candid, Dan. My daughter is the one that got me to call you and say, okay, I'm going to commit to coming to this.
Well, thank God for Eleanor. Our paths may have never crossed, and the trial lawyer world would not be the same for sure. But yeah, thank God we got past that little hurdle we had to get past. But
that little 2-year hurdle.
Little 2-year hurdle, that's all right. Because Charla, I had to get her on my radar because Brian Panish, who's not one to mince word, he's like, Charla Aldous, she's a real trial lawyer. I'm like, wow, from Brian Panish, that's some street cred. So you weren't always meant to be a trial lawyer, or maybe you were, but some people didn't know it. So tell us how it is that you got the little idea, as a young girl in Sherman, Texas, to become a lawyer.
Yeah, Dan, I was raised in Sherman, Texas, which is a small town 60 miles north of Dallas, and a Pentecostal preacher. So my childhood consisted of praying in church and praying in more church and praying in more church. Education was not really at the top of the list. So when I was in high school, I was in the vocational office education program where I'd go to school for half a day and then work for half a day. And I remember like yesterday when I was in my VOE class one day, they had a lawyer from the Twin City of Denison, it's a female woman, she was a family lawyer, come in and talk. That was the first time I had ever met a real lawyer. And she was talking about the practice of law and the opportunities for women, it was all women in the VOE class, to work in law firms. And I thought, that's what I want to do. I want to be a legal secretary or possibly a legal assistant. And with that goal in mind, I enrolled in Grayson County Junior College. We called it Harvard on the Hill. And I took vocational classes. And I had one core class, a history class, and a professor took a liking to me and said, Charla, why aren't you taking the core classes to get an associate's degree? Aren't you going to go to a 4-year college? And I said, no, that wasn't my plan. And he said, well, what did you make on the ACT or the SAT? I said, well, I haven't taken it. And he said, do what? Anyway, that man was the first of 2 teachers or professors that changed the trajectory of my life. He talked me into getting an associate's degree to take the ACT and get accepted to a 4-year college, and I did. I worked full-time during all this time, and I went to Austin College that is located there in Sherman, Texas. It's a really good liberal arts college. And as luck may have it, my professor that was my mentor, Dr. Ken Street, was a constitutional law professor. And I loved that class more than anything I'd ever taken. And Dr. Street took me aside and said, I want to talk to you about your future. He said, you were born to be a lawyer, and I don't say that to many people. I want you to really, really think about going to law school. I said, but Dr. Street, I can't afford it. Blah, 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 all the excuses. And he goes, no, we're not going to take any excuses. This is what I want you to do, and I will help you every step of the way. I get teary-eyed when I think about it because he truly changed the entire path for me. I took the LSAT. I was married. I got married when I was 17 and was working, so I couldn't go anywhere but Dallas because I was commuting from Sherman. I got accepted into Texas and Baylor and SMU, and I went to SMU. And I did moot court and mock trial, and I knew I'd found my home. I absolutely loved those trial courses. I also did the criminal clinic where I actually tried 2 DUI cases while I was still in trial with a provisional license. Would go down to the jail cells on Monday morning and meet the clients. And then I did civil clinic helping poor people. And that's how I became a lawyer.
Well, that's a pretty, what's that word? Not a direct line. because like my dad and two of my brothers and sisters were all lawyers, so it was like an easier, like not even like a thought not to be a lawyer. What does VOE stand for though? Vocational
Vocational
something?
office education.
Got it. But it was only women
You
in
have
the
to be raised
class.
on my side of the tracks to know what that means.
Got it. Got it. We didn't have those where I grew up either. So, but that was a great start. And so you went to Southern Methodist SMU and took moot court. And then one day you took the bar exam and you came home and there was an envelope in the mail that said, I'm sure it said like, congratulations, you passed the Texas bar. And so from that day, when you got that letter to today, when we're sitting on our podcast talking about stuff, tell us about that journey and the stops along the way.
Speaking of journey, I'll tell you a little bit about my literal journey in law school because everybody thought I might be a criminal lawyer because of this. But I was commuting to Dallas from Sherman every day, and I had a CB radio, and my bar handle was misdemeanor. And the truckers would always get tickled, like, here comes misdemeanor, going to blow your doors off. 10-4, 10-4, there's smoky up there, put the pedal to the metal, take it off, misdemeanor. It was so much fun. So when people heard that my handle was misdemeanor, they assumed I would be a criminal lawyer. That, however, never really interested me. So I was living in my hometown of Sherman, population 30,000. And there was one job opening, and it was with an insurance defense firm called Henderson, Bryant, and Wolf. And there were like, I think 9 or 10 lawyers. I was the only associate and the only female. So you can imagine how things ran downhill at that firm. But it was a great start for me. I was very, very appreciative to have the job. I got a salary, and then I had to bill so many hours in order to get a bonus every year. The problem was I didn't have enough work to have enough hours to get that bonus. So I started doing traffic tickets, and I could quash the best traffic ticket in Grayson County. And I became known as the traffic queen of Grayson County. And I tried a lot of traffic cases in municipal court, picked juries, and people could laugh at that. But I always believe that a jury is a jury is a jury. And I don't care if it's the smallest case in the world or a multi-million or billion-dollar case. It just helps to have that kind of experience. Anyway, from there, I had my first child. I have 4 children. And my obstetrician gynecologist got sued for malpractice. And he came to me and said, Charla, I want you to be my lawyer. And I said, well, doctor, there's a real problem with that. I know nothing about med mal. And he had confidence in me. He said, I don't care. I want you to be my lawyer. So I met the insurance adjuster for medical malpractice claims through that, and he and I hit it off, and he believed that I had some talent and started using me to defend medical malpractice cases in smaller communities in Texas. And I tried a lot of medical malpractice cases. I started out really not knowing what I was doing, but having an ability to relate to juries, and that's kind of how I got my start.
What happened with your obstetrician's case?
It actually got dismissed on summary judgment. I was just local counsel for him. Another firm in Dallas, Coles and Thompson, represented him. But as a result of my work with them, they wanted me to open eventually a Sherman office to do medical malpractice. And I did car wrecks, I did everything kind of work. So that case kind of gave me an entree into the Dallas market. And so I opened a Sherman office for them. I eventually moved to Dallas, and several of us at Coles and Thompson left and started another firm. It was Cooper, Aldous, and Scully, now called Cooper and Scully. So I did defense work, insurance defense work for, I guess, 13 to 15 years probably.
Wow. How many cases do you think you tried as a defense lawyer?
Oh, over 150. I mean, I was literally in trial just about every week. My last year at Cooper, Aldous, and Scully, I tried 13 cases to a verdict. Some of them were car wrecks, a lot of them were med mal, but I would literally pick up a file on Saturday and start the trial on Monday. But I had a great team supporting me.
The team is everything in this legal business, because not too many
that is so true.
guns out there.
Totally agree. We all have gifts, and you got to use those gifts, and they come together to make a great team. I always say that I see the law as an impediment to the jury. I need people smarter than me surrounding me to help me with the legal issues. And so I did. I had a great team at Cooper, Aldous, and Scully that helped me be able to try that many cases.
So you started your own firm and you had it for how many years before you decided to do something else?
Cooper, Aldous, and Scully, I was there probably 6 years. I'm losing track of time, about 6 years. And one thing that I haven't told you, I don't think, is what happened. I tried a case. That firm had a plaintiff's case out in Wilmington, North Carolina. And I had told the firm that my husband at the time was wanting to move to Austin to go with a great firm down in Austin. And so I was thinking about taking some time off from the practice of law to move with my family and kind of figure out where I was going to go. I don't share this story very often. So I told him, I said, I tell you what I'll do. I'll go try this plaintiff's case. I didn't know much about it in Wilmington, North Carolina, so you won't be quite so mad at me for leaving the firm. We represented 128 trailer park residents whose well water, and it's water in North Carolina, were polluted by methyl tertiary butyl ether, a additive in gasoline that, quote, made it safer. And it was the first MTBE case tried in the nation. We tried it in the federal court in Wilmington. So that was my first experience doing plaintiff's work. The second day of trial, those dirt poor clients bought me a gold-plated Guardian Angel lapel pin, which I've worn in every trial since then. And that's when I thought, this is what I want to do. It was so fun representing the little guy against the big corporation. There were I think we had 4 lawyers, plaintiffs' lawyers on our team. I was the lead lawyer. We had 1 legal assistant, and Conoco probably had 12 lawyers and 50 support personnel all over the courtroom. And I loved being David taking on Goliath.
So what happened in that case?
Well, we did some fun stuff. I did not tell my team I was going to do this because I thought they would freak out. But we did jury selection, and the judge was great. He had a bolo tie. He was a Jimmy Carter appointee, so I thought he was probably going to be a little bit friendly. But I did have a backup plan if this didn't work. But he told me to call our first witness. And I said, Your Honor, I call whomever on behalf of Conoco is going to tell this jury if they take responsibility for polluting my client's well water. Well, the Conoco lawyers had seersucker suits and bow ties, were all over there convulsing and hobnobbing, talking. And they turned to the judge and said, Judge, can we have a name? And I said, Judge, I'll take anybody on that side of the courtroom. This case has been going for 2.5 years. Whomever is going to tell this jury if they take responsibility for polluting my client's well water. Anybody they want to put up there. And they all convulge again and talk. And the judge says, well, she has a little bit of a point, counsel. Why don't you just put somebody up there? So they called the vice president of the East Coast division of Conoco. He had reptiles in his background. I don't know if he's a Gila monster or an iguana, but he was just reptilian. Had a real red tie, all straight, and it was fun. I got to prove the case through this guy. But really didn't know much about it other than he was disdainful of people that lived in a trailer park, which that's manna from heaven. It was really fun. So our case was medical monitoring. Our clients had not been injured yet, but they had had dogs and cats that had died, and this was a carcinogenic, so they had fear of cancer. 0 offer. We were in trial about 6 weeks. And the jury came back and gave us, I can't remember how much it was. I want to say $10.5 million, whatever we had asked for medical monitoring for our clients. And they found fraud and gross negligence. So the jury it was a bifurcated trial, and the jury was going to go out and argue punitive damages. Well, on their way out, there's a woman on the jury named Miss Smith, little gray-haired, sweetest little woman. And she came up to me and said, now, Charla, can I get your card, please? I said, no, Miss Smith, we better wait just a little bit. And so we got to put on evidence of how long it would take Conoco to pay that verdict, and it was like 30 seconds of profits. And while the jury was deliberating punitives, we settled the case. And it was just a wonderful, wonderful experience.
Well, that's a good way to start out your plaintiff's career with a nice 8-figure result. It's good because, it's plaintiff's law. You need a little bit of a nest egg to get started, and so instead of walking away from your defense firm to go retire or take a leave of absence in Austin with your family, you decide to shift gears and become a plaintiff's lawyer.
I did move to Austin and took some time off for a while, and then I realized that I needed to be back on my own, and I came back to Dallas and started my firm, put out my shingle, held my nose, jumped off the cliff, and prayed God would let the phone ring.
And how old were you when you did that?
How
How
old
many
I
years?
was, I always have to go back to how old my children are. I was about 37, 38.
When you started your own firm?
Yeah.
Wow, good for you. And so now today, so that was, what year did you start your own firm?
I'm 64 years old, so you do the math, Dan. I'm not good with
I
math.
don't know, 26 years ago, I'm guessing.
Yeah.
That's
26,
so
27 years.
you started on your own, and what does your firm look like today?
It's still small. I was a solo practitioner for a long time, and then I hired, who's now my partner, Brent Walker, about 13 years ago. And we have two associates, Caleb Miller and my daughter, Eleanor Aldous. And
Thank God for Eleanor. Thank God for Eleanor.
she is the
Get
one that talked me into. She's making
special love from TLU.
Eleanor's giving me a little push, saying, "Okay, let's get this show on the road, Mom. We got to grow a little bit." I've always intentionally wanted to stay small because I really like to know all of my clients, and I'm involved in every case in the office. We're kind of transitioning to start taking some smaller cases now, simply so Caleb and Eleanor can get trial experience. But historically, we've just taken, the catastrophic cases, and we've done a lot of pro bono work, which I'm really proud of. But my firm has handled all kinds of cases: offshore tax shelter case, sexual assault, products liability, dram shop, wrongful death, personal injury, birth injury. I've tried all those types of cases.
Wow, it's a big array of work, because each one's a lot of work,
Yeah, it's a challenge. I love learning new things, and keeps it interesting, keeps me on my toes.
You have to, but that was a great victory to start with. But I think we all have some losses that like really bother us. I know I have one that just still bothers me terribly. So what loss in your career like still I always think it's like, if I had the skills then and knowledge and strategy that I have now, I would crush that case. But I did my best.
When you ask me that, there's one case that immediately comes to mind. For some reason, I seem to remember the losses more than I do the wins, because I take it as personal rejection. I just am devastated. But I do believe if you haven't lost any, you haven't tried many. And the true test of a trial lawyer is to lose bad, and get on that horse and go again. But the case that I remember is, it had to be at least 24 years ago. And I represented a woman named Becky Stevens. And Becky Davis. And it was a failure to diagnose breast cancer case. And we had two culpable defendants, the radiologist and the surgeon. The surgeon had X number of insurance, and he was really the target. And his carrier offered their policy, and he offered money over and above the policy. He felt really bad about what had happened. It was clear malpractice. And I made the mistake of youth and took that settlement. And the reason I say the mistake of youth, I was thinking, well, we're not going to get any more money out of him, and this can help the family right now. In reality, that money was never going to go away. I should not have settled that case and left the empty chair, because we tried the case to a verdict, and the radiologist, of course, blamed the surgeon. The surgeon wasn't there to defend himself, and the jury put all of the liability on the surgeon, and they awarded, I can't remember, I want to say 10 to 15 million. It was a substantial amount of money, but it was on the settling tortfeasor. So what I learned in that case is never, ever, ever let the target go. Keep it close to the chest, try the case to a verdict, and then talk about possible settlements. Becky died about 6 or 8 months after the verdict. I'm still friends with her husband and her daughter, who just had their first grandbaby. And they are grateful because we got them quite a bit of money from settling, and we're devastated about the loss, but still happy with our services. But I will forever regret the decision I made, and I hate that we lost that case.
There's really no. It's like losing sucks so bad that it's hard to put words around it.
It really is.
Thank God it doesn't. Thank God as we get older and better, hopefully it doesn't happen as frequently, because it's just such a public rejection. Like so many.
Really is.
Because it's like young lawyers have to be careful about going to trial on crappy cases and getting shellacked, because they're like, oh, I'm just getting reps. I'm like, be careful, because you got that thing called an ego and a self-image, and it can only get battered so long before it's like, need to, this is not for me. But tell us about, what case, I guess, are you most proud of in your career?
Gosh, it's usually the case that I'm working on at the current moment. But if I had to go back and think about which case I am most proud of, it was probably the Jane Doe versus Episcopal School of Dallas case. It was a case involving sexual abuse of a student by a teacher. And I took the case on just because my heart broke for this young woman. She was 16. And she came to see me. I remember her sitting in my office with her parents and her sister, and the kid was suicidal. It was horrible because not only had she been abused, and this is one of the fanciest private schools in Dallas, not only had she been groomed and abused by her teacher. After the school, the police caught the little girl and the teacher in a parking lot, and it was reported. And the school let the teacher resign. And what they did, this Christian school did to this student who was the victim, is she had gone with her mother to a college visit about 3 weeks after this was learned. And they called her father into the school and said, and her 3 older siblings had attended the school. She'd been in this school for her entire career. She was a junior at that time, her entire education. So she'd been there 15 years. And they told the father, they said, you're going to have to withdraw Jane from the school. And if you don't, we will expel her. And there is no door number 3. And they put this literally in an email, a memo to the file. And the dad said, you can't do that. There's rumors that Mr. Campbell, who was the perpetrator, had a relationship with a young woman. I hate to even call it that. They're going to know that it's Jane if you kick her out. Please, please, please don't do this. And they said, nope, there is no door number 3. So they literally made that young woman who had gone to that school her whole life, she never stepped foot on the campus when she came back from looking at colleges. Her parents had to tell her she had to withdraw from the school. And to say this was secondary victimization would be an understatement. And when I heard about the case and when she told me about it, I'm like, I've got to take this. I don't care if there's money in it or not. This is disgusting. So we filed suit, and it never crossed my mind it would get attention, media attention. But it hit the news in Dallas. And when we tried the case, one of my best friends from Sherman, she was a defense lawyer, but I asked her to come down and try it with me. She's since passed. She was my very dearest friend. And she tried it with me, and there were daily blogs for the Dallas Morning News and some of the other news stations, and they called us Thelma and Louise. They said, Thelma and Louise have arrived at the courthouse again. Here they go. And Cindy and I would fight over who was Susan Sarandon and who was Gina Davis. It was a lot of fun. But there's coverage every day. The school started offering a little bit of money about 2 weeks before trial. But I told them, you don't understand, we will not settle this case for just money. There are going to have to be some changes. The 3 people, who was the father, the Episcopal priest who founded the school, and the vice president of the school, and the head of the upper school, those 3 people will have to leave because they should not be taking care of children, given how heartless they were to this child who was a victim of their lack of oversight of a teacher. And I meant it. And the family was behind me, and Jane Doe was behind me. And they didn't think we would take it to a verdict, that we would take the money, and we did not. It literally, the trial, there were so many people in the courtroom that the judge had to pipe the sound to another courtroom so the overflow people could be there. I told my daughter was interning for me that summer, and I told her, I said, I feel like I'm at the Botox convention of Dallas because all of these rich moms from the PTA group were there staring at me, giving me dirty looks the whole time. I'm like, you don't understand. I don't need to go to your country club. I'm quite fine. Anyway, I got to tell you one funny story. They hired a good friend of mine who's a state senator, Senator Royce West. The school hired him because we had 6 women on our jury, and 2 of them were black, and I believe they hired him for that reason. But I told him, I'm just glad a Democrat's going to make some money off these bastards, so welcome to the party. And Senator West tried to get the case settled, but at one point during the trial, he stood up and said, Judge, will you ask Miss Aldous to please use her inside voice? Okay, we have all-female jury, sexual abuse case. And I said, I'm so sorry, Your Honor, but my outside voice just comes naturally because I've had 4 kids. And he said, well, I have 7 kids. And I looked at the women on the jury and said, well, I birthed my babies. And he said, well, I cut the cord. And I looked at the jury and said, snip, 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 pin a red rose on him. It was so funny. To this day, when I see Senator West, I go, snip, snip. And he goes, don't do it. Don't do it. So there were some moments of levity during the trial. But I usually don't get nervous in trial. I don't know why. It's the first time I tried a case, I thought this is where I belong. I love it. I just absolutely love it. But in that case, I was nervous. And I was nervous because this little girl had been abused by her teacher. She had been kicked out to the curb by this Christian school that was supposed to protect her. And I thought, dear God, what is going to happen if this jury finds against us? It really did cause me pause. And I did not have her attend the trial. She came in for her testimony. And the day that she was going to testify, I was walking down the hall holding her hand. And there was a teacher from that school who had about 10 students on the pew outside the courtroom there to mock her and hiss at her as she walked by. And I said, Jane, hold your head high, look straight ahead. You are fighting for justice and you're on the side of justice. And that kid was so strong and just did a fabulous job. And the jury came back and awarded us, I should have checked this, Dan, I think it was $10.5 million. It was either 9.5 or $10.5 million. And they found gross negligence, awarded punitive damages. Media was all over the courthouse when the verdict came back. Even national news media picked up the story. And it was just a beautiful, beautiful, beautiful day. And afterwards, we went to a post-verdict mediation. And I said, I'll tell you the same thing now that I told you 2 years ago. We will settle if Father Swan, Rebecca Royal, and I can't remember the other one's name. I disliked her so much, I can't remember her name. If they go, and they were terminated from the school. And then we got quite a few $1 million in settlement. It was confidential, but that case was, it really touched my heart. Long story short, Jane went off to college and then she went to law school. I was at her law school graduation. Her grandfather was a retired admiral in the Navy and was elderly. She was getting married. She got married in Florida. I read the scripture at her wedding. When I saw her walking down that aisle with a white dress, I just lost it. And now she is, I'm not going to say which firm, but she is a plaintiff's lawyer in San Francisco with a damn good firm. And she is handling sexual assault cases.
Wow. Talk about perhaps being born for a role, and through the life of, nobody asked for these things, but
it's just amazing. She always says, you're my angel, you changed my life. And I love it. She'll text me, she's going to mediation. She's like my fifth child. But that kid was so strong. I was on an International Academy trip to out of country, a foreign trip, and one of the partners of that firm came up to me and said, so I heard you know Jane Doe. He had no idea how I knew her. And I said, yeah, she's from Dallas. She's a good friend of mine. He said, she is one of the toughest, most outstanding young lawyers I have ever met. And this is one of the senior partners of that firm. He has no clue what that kid went through. But I feel like I gave her a voice, and now she is a voice for others. And that feeds my soul.
I can imagine the food for the soul that would be. Wow, so what was the punitive damage verdict? Of course, you leave these cliffhangers out there.
The punitive damages was what I asked for because I didn't want it to be so high that the Court of Appeals would knock it out. I think it was like $600,000. We didn't ever do that case for the money. We did it, but we got enough that it paid for Jane Doe's education. It paid for her law school. Gave her some money set aside, and I gained another child.
Look at that! It was something you never expected. I'm sure. Well, let's.
I always do that, though. I tell my clients, Dan, in any case, I said, I want you to know, lose, win, or draw, I want something to remember you by at the end of the case. And I've got original birth handprints and birth injury cases. I've got Bob Garrison was a failure to diagnose cancer case, and his only goal was, Charla, just make sure my wife and kids are taken care of when I die. And when he was going through chemotherapy, he had a hat that he wore. And we settled the case literally 2 weeks before he died. He came to my office to sign the settlement agreement, signed it, took off his hat, and put it on me. That hat is on the wall in my office, and it's those mementos that remind me why I do what I do. God forbid that it's ever just about the money. It needs to be about people and helping people.
Well, on that note, Charla, let's talk about helping some other people called trial lawyers get better, because unfortunately you're not able to come to Trial Lawyers University, Las Vegas, which is October 16th through 19th, because like so many of your good friends are going to be there from the inner circle, and so many great trial lawyers from across the country and trial consultants. We have, Eric Oliver and Sari De Lamott and Jesse Wilson and Harry Plockett. We have like a whole list of like some of the best trial consultants in the country. Not your trial consultant, but some of the best ones in the country that we're excited about. But you will be joining us June 4th through 7th in Huntington Beach, California for our fourth TLU Beach event. So what will you be teaching there?
And let me tell you this, when I told you I committed, I am committed. I've even told my office, do not schedule any trials during that time. It's in concrete on my calendar. And you asked me what I'm going to teach about, and I got to say, oh gosh, what can I teach somebody? But the two things that come to mind is voir dire. We don't call it voir dire in Texas. You get kicked out of town. You call it voir dire, but obviously your case is only as good as the jury you pick. And I love that aspect of it. And so I'd like to teach on voir dire, trying to get my good friend Lisa Blue to teach as well, because she is the master of voir dire. And then I'd like to teach on cross-examination of corporate reps, because that's the funnest thing. After voir dire, that's the most fun thing, I think, to do in trial, is to prove your case through a corporate rep. Much like when I didn't even know what I was doing in that Conoco case, it's what we did. And it was great.
That would be a good exemplar trait of trial lawyers, in some way, being fearless. Because Colin, just for that the Conoco case, like anybody you put up there, just somebody admit it. It takes a lot of courage. It takes a lot of guts to say that in a courtroom, especially a courtroom you're not familiar with, a judge you don't know. I have to give you props for that. A lot of credit, a lot of courage to say that. All right, well, let's.
What you always have to remember as a trial lawyer, and this is what the reason I think I'm not afraid in trials. I mean, I don't like to talk to a bunch of lawyers. I'll be honest. It's just the Charla from Sherman comes out in me that was on the wrong side of the tracks in Sherman. I don't like it. But talking to a jury, those are my people. I can talk to juries. I mean, it's just, I think it might have been me talking in church and, hearing my dad preach. And I'm like, praise the Lord and pass the offering plate. Let's go. I can do that. So I would love to teach to the extent that I can teach anything. But the main thing is be authentic and just remember you're talking to just regular people.
People always talk about authenticity, but I don't think authenticity is something you really be. It's something that I think you have to become, because you just have to make sure that you get whatever you have to do. Like you said, you don't ever get nervous. Well, if you don't ever get nervous in court, well, then it's easy to be authentic because you're just relaxed. But for most human beings, stage fright and nervousness is a part of our soul. And I think that the only way to get through that is to keep getting up in front of people, but also to keep practicing getting up in front of people and being intentional.
But I get nervous speaking to a bunch of lawyers. I mean, don't get me wrong. It's not that I'm invincible. That makes me nervous, but jury trials don't.
Well, I'm glad you're human, Charla, and you get a little bit nervous.
I am very, very human.
Very human, very human. All right, so now we're going to get some trial strategy tips and content. But we have to do it in the context of not your last trial, because I know that one was a whopper. It was a great result, but it's on appeal. We don't want to talk about cases on appeal, but the one before that with the Greyhound bus that you got a verdict on. So tell us a little bit about that case so we could talk about the different parts of trial and get some context.
And I have tried some between the Greyhound case and the one we just tried, the Walker engineering case. We got a $72 million verdict. But I want to talk about the Greyhound case because I think there's so many learning points there. I was contacted by a lawyer in Portland, Oregon, and Jane Paulson is her name. She's with John Coletti. They have a firm. And she said, I have this tragic case. We have a cap in Oregon that I'd really like to file it in Dallas if we can, and it's against Greyhound bus lines, and Greyhound is based in Dallas. So that's how I got involved in this case. And we represented the parents of Hunter Becker Brown. His grandmother would say the sweetest boy in town. I'll remember that forever. And we represented Hunter Brown, and his father, Barry Brown, was a physician, an emergency room physician. His mother, Paula Becker, was an artist. And Hunter died in a very tragic way, but there was so much more to the story than just Hunter's death. It was the tragedy of a part of his life, because Hunter was addicted to hard drugs, heroin, cocaine. And I learned this when I would tell Paula, his mom, he was a drug addict. She said, please don't say that. Say it was my son who had an addiction, because being a drug addict, it labels somebody. That's just one very small thing I learned in the case. Anyway, Paula and Barry had been fighting Hunter's addiction for years, had to kick him out of the house. Paula even wrote a book about losing your child to addiction called A House Built on Stilts, because they had a tree house in their backyard. And when they would draw the line and kick Hunter out and say, you cannot be here if you're using, she would look out the back window and he would be living in the tree house. And she would go and leave him food out there. It was just every parent's worst nightmare. They had 2 other children, perfectly good kids. Not that Hunter didn't have a good heart, but they had no addiction. So this family had been devastated by the addiction of their child. He was 20 years old, and he called his parents, and for the first time, he said, Mom and Dad, I want to get clean and sober. Will you help me one more time? Because they had, when he was a minor, had forced him into rehab. But he was an adult, so he could make the choice. And they said, yes, we will, Hunter. We will help you. And so they found a rehab facility in California. They bought a burner phone. They gave Hunter a Greyhound bus pass and $10, because they knew if they gave him any more, he would most likely use it on drugs. I mean, you got to understand, they would wander the streets looking for the homeless people trying to find their son. It was just horrible. So they had hope. Paula made his favorite sandwiches, made the cookies that he liked, and they took him to the bus stop and put him on the Greyhound bus for the travel to the rehab facility. There was a bus stop about, I think Hunter was about an hour and a half into the trip. And the driver said, we're pulling over at this bus stop and we'll be here for, I can't remember the exact amount of time, but let's say, for argument's sake, 10 minutes, and then we're leaving. Well, Hunter went into the bus station. He used the restroom and was buying some food or a Coke or something. And he was the last one coming out. Well, everybody but Hunter got on the bus. The driver did not do a head count, which was contrary to Greyhound's policy, and started pulling off. We found witnesses. They were saying, stop, stop, stop. You're leaving somebody. You're leaving somebody. Hunter came running out of the truck stop. The driver of the bus kept going. Hunter ran up the side of the door, beating on the side of the door. The bus driver would not stop, kept going, turned his wheels, caught Hunter's foot, and drug him under the bus, and it killed him. Literally just smashed his brains all over the parking lot. It was horrible, horrible, horrible. What we found out is Hunter was high on heroin, and he had a syringe in his pocket and some heroin in his pocket. So obviously, Greyhound argued the reason he ran out off the bus because he was high. Any sober person would not have done that. So it's not our driver's fault. He was obeying policy. It's Hunter Becker Brown's fault. So they offered very small amount of money before trial. And, you know, what I say about cases like that is you can't fall out of the basement. So if they don't offer you anything, put your trial boots on, you go to trial. And we tried that case, and it was an emotional trial, and as I anticipated they would. The defense, even when they put the mother on the stand, said, well, you'd already lost your son before this happened, and they showed her quotes from her book. And she pretty much took their head off. She said, how dare you accuse me of that? My son was not dead. So anyway, we tried the case to a verdict. We got 28 or 38 million. It was quite a bit of money. And they put 10%, the jury put 10% on Hunter and 90% on Greyhound bus lines. And, you know, some people, I think, would have looked at that case and say, you've got a client that was high on heroin chasing after a bus. No way. But I saw it as, for these parents, even a bigger tragedy than losing a healthy child, if anything can be bigger than that. And that is losing a child before you have redemption, because they had hope that their child was going to get sober. They had increased hope when he was going to rehab, and then to lose him in such a tragic way. And I tell you, it was amazing talking to the jury afterwards. The drug addiction had nothing to do with their verdict. They were offended that it was even brought up. And I called their Greyhound's corporate rep as our first witness, the head of safety. And, it asked him hypothetically, if you were in the middle of nowhere in Portland, Oregon on a bus and you had a burner phone and your phone was on the bus and all you had was $10 in your pocket and you're in a bus station and the bus was pulling off, don't you think you would run after it to try to stop it? That was our theory, that the drug use didn't have anything to do with Hunter's actions. So that was a really meaningful case. The parents with the money set up a foundation for addicted teens and are doing a lot of really good work for homeless youth in the Portland area, which is so cool.
That is pretty cool. But let me ask you, so we're going to do a complete case analysis on this verdict on September 4th at 10:30 Pacific time, 12:30 Dallas time. And then we're going to, break down each part of the case. But I just want to talk about different aspects of the case and your preparation for it. So like the 90 days before trial, what are some of your processes that you use to get ready in obviously this case, but every case?
I'm embarrassed to say the process usually doesn't start 90 days before trial because I've got so much going on.
Okay, 30 days.
I'd say 30 days. The first thing that I do is read the depots, and I want to read the depositions myself, not summaries, but actually read the depositions of everybody that's been deposed. And then it depends on the case. If it's a medical malpractice case, it's then reading the medical records and then the medical literature. But in Hunter's case, it was reviewing all the policies and procedures that Greyhound had, in existence at that time and things of that nature. But the starting point for me is reading the depositions.
All right. How about focus groups?
I hate to say this, but I have historically not used focus groups, and I probably should, except for a different kind of focus group, which I've done for about 9 or 10 years now. And I don't even know, it's called more of an online jury study. I can't remember exactly what they call it, but I use a guy named John Campbell, and it used to be Empirical Jury, but now it's just Campbell Law Office. He was a plaintiff's lawyer and then was a professor at the University of Denver Law School. And John does focus group type studies, but he does them through the internet with large audiences. I'm talking 800 to 900 people. And we used him on Hunter's case. And what he does, it's just unbelievable. It's scientific, and he could explain to you better what the science is behind it, but it has proven true every single time. John gives me a report. Sometimes I use portions of that report for settlement purposes when I'm trying to settle a case. But it spots issues in the case, and he gives you the percentage of time they're going to put, contributory negligence on your client and what the verdict range could be. For instance, in Hunter's case, he said there would be 8 to 10% on Hunter. He gave me the verdict range. We came right in the middle of it. And there have been cases where it was a case I tried in Orange County, California, and I got involved late, and we just did one of his studies after the trial started. And he said, Charlie, you're going to lose 7 out of 10 times. Settle this case. And we got a high-low before the jury came back, and I would not have done that but for John Campbell. So we do use John on our cases that go to trial. He helps us spot issues, and he also gives me the assurance that my evaluation of the case is pretty right. And another thing he's taught me is he does categories of asking and sees if he asks for 100 million, what is the verdict? If he asks for 150 million, what is the verdict? And through his studies, I have become convinced that you need to ask for the big dollars and you will get a much higher verdict than you ever would. Like the case that we just tried, it was a wrongful death case. I asked for 190 million. I normally would have asked for like 60 million. Well, the jury gave me 72 because I asked for 190. I was always afraid that it would make them mad and go the other way, but it's not true. So that's a long way of saying I use John Campbell for these online focus groups on any substantial case that I have.
And they just published a new book, John Campbell and Alicia Campbell and Sean Claggett, called Jury Ball. So they just, they released the book at TLU Huntington Beach, and John, Alicia, and Sean Claggett, who is the co-authors, are all presenting on big data quite a bit in Vegas in October. And there's a lot of, he's hosted a lot of webinars that are on TLU On Demand with folks like you that had, used their data and got some great results. And I personally know at least 4 people who got their first 8-figure verdicts because they did these studies. And I think the thing it gave them the confidence and the belief in the number, other than, picking a number out of the clear blue sky, because otherwise, that's really what it is, isn't it?
That's exactly what it is. I hate to say this, John had asked me to do an excerpt for his book, and I was in the middle of trial and didn't get it done. So I'm sorry, John, if you hear this, that I didn't do that. But I can't tell you how important their work is. I am thrilled to know they're speaking at Trial Lawyers University because it is a tool that every plaintiff's lawyer should use if they can. It gives you confidence. It helps you evaluate a case. It spots issues. I've had some cases where John has done 2 or 3 reports for me. And everything else aside, he and Alicia are just such great people, and Sean is as well. They are just a real good resource for any plaintiff's lawyer.
And I know they have this Fred AI that they just started releasing recently for smaller cases to get, smaller studies so people can still get some good data information around those smaller cases. So
exactly.
Now we've talked about preparation a little bit, but let's talk now about voir dire and your approach to
Come on, Dan, you got to work on that voir dire.
Voir dire.
There you go. You did it. You did it. You sound like a good Southern gentleman now.
Thank you, voir dire. So on voir dire, tell us, your approach when first your mindset when you first stand up there, because I know you're not nervous anymore. It's like a lot of folks are. So what's your mindset when you first get up there, and how do you start off?
Well, my approach to voir dire in the last decade is much different than it used to be. I used to think that's when I need to try to sell my case, and that's just all the studies have shown that is not what you're supposed to do. Your goal in voir dire is to get the bad people off. And by way of example, if I have a catastrophic injury, somebody that's a quadriplegic, I never mention that in voir dire when I'm talking about hundreds of millions of dollars for mental anguish, because most people would say, well, yeah, if they're quadriplegic, I could. But I make it look like they're not that badly injured, so I can get the people that even having a leaning towards limiting damages off the case. Now, the defense usually get up and say how bad my client's injured. But that's one example. But you got to connect with people, and you got to connect with the people that you really don't like, according to the data you see on the card or the questionnaire, because those people have to talk, and you have to loop them in to get others to talk to try to get them off. The case that we just tried a month or 2 ago, it was one of the worst panels I've ever seen in Dallas County, and my jury consultant, Jane Frazier, I've gone with me to trial for 15 years now, she said, you need to bust this panel. I said, okay. And so I started going and busting it. And I turned to her, I said, I still need to bust. She said, not yet, just keep going. And we finally got down to where we had one more that we needed to get off. And she said, stop, don't bust it. We can see the jury. So I love that aspect, the challenge of trying to get the bad people off. And I think you have to do it by just getting the people to talk. And that sounds really easy, but it's really hard sometimes. I oftentimes started out by, hey, I'm Charla from Sherman. Thank you very much. And how many of you are thrilled to be here today, or can't think of anywhere else you'd rather be than in Dallas, Texas on these hard benches? And, none of them raised their hand. I said, okay, we got truth tellers. We're off to a good start, but you got to kind of get it going. And if you say, good morning, ladies and gentlemen, good morning. Now, come on. We can do better than that. You got to get some excitement going and make them feel important. I get excited just talking about it. And sometimes I'll read like I'm reading off a jury card. I said, my name is Charla Aldous. I was born in Sherman. I went to Grayson County Junior College. We call it Harvard on the Hill. I'm divorced. I don't cry about it anymore. I'm actually quite happy about it now. I have 4 kids, blah, blah, blah. So what you've done is you've humanized yourself with the jury, and then they have a tendency to want to open up to you more. And most importantly, you got to have excitement. I mean, you got to make that courtroom be alive. They got to think, oh, this is not going to be so bad. This might be a little bit of entertainment. So that's the way I start off and approach voir dires.
And so after we get started, though, I want to talk about like your sequencing of topics and how you think about after you get your connection going with that bit there. I can see that's very effective because you're sharing with them what they've been asked to share. And so, how do you think about, especially the topics that are specific to the case of, for the young man on the Greyhound? I'm sure you had to talk about comparative fault. I'm sure you had to talk about the use of drugs. And so how do you talk about those topics in that case?
Well, what I usually do with voir dires, I start with the burden of proof. How many of you watch law television shows? Raise your hand. How many of you, which ones do you watch? I get them talking about which shows they watch. It's a criminal case. What's at stake? Liberty. What's the burden of proof? And then who knows what the burden of proof is a civil case. And then I tie that in with, some people just think that's really, really too low. They would absolutely hold me hot to a higher burden of proof. Then I tie that in with millions of dollars in mental anguish. Would it need a higher burden of proof? In Hunter Brown's case, trying to remember this, it's been a couple of years ago, is I talked about addiction. How many of you have had a close family member or a close friend that have suffered from addiction? Not to get those people off, but just because I wanted to identify them to know which ones I thought would actually be favorable for me and to get the discussion going. Addiction is something that our society deals with. It's horrible. Do you think a life is less valuable because that person happened to have an addiction? Another topic that I hit head on in that case is this is a case about parents suing over the death of an adult child. Some people might just see that as blood money. Could not award money for that, no matter what the circumstances are, because the kid is dead. He's not going to come back. So get discussion going about that. And I found that a lot of people feel that way. You lose your child, you shouldn't get money from it, which, you can instinctively understand. But then it comes about accountability, so it won't happen to another child. I usually, if the judge allows me, always talk about millions of dollars. I'll say many millions of dollars. Sometimes I'll say 50, 60, 70 million. Is there a number that you could not award for mental anguish? Talk to them about that. A lot of times I don't put compensatory damages in a case because I think it anchors them, that it keeps the verdicts low. In Hunter's case, we asked for his pain and suffering for his estate, and they ended up giving a lot of money for his pain and suffering, although it was just a few seconds that he was pulled under the bus and he knew he was going to die. So I talk about that. How many of you were suing for damages to his estate for the conscious pain and suffering he had? Some people just say, we never know if he suffered or not, and I could not give money damages for that because he's dead. That was another issue that we had to talk about. And the main thing to remember in voir dire is just get the people to talk. And Jane is with me. And when I first talk to her during the middle of the voir dire, I tell the jury, I said, you're going to see me talking to Jane quite a bit here. I want you to know that's a good sign. Because if I talk to her, that means I'm going to ask you fewer questions and you're going to get to leave sooner. So that kind of takes out the awkwardness of it. And so I'll say, hang on just a minute, I got to talk to Jane. And they look, oh, well, she's going to go talk to Jane. That means we're going to get out here sooner. I've watched it. They like it. They like the interaction, where I think some lawyers would think, oh, I can't talk to her because it's going to make me look stupid or it's going to be awkward. Just be comfortable. Let me talk to Jane for a minute, and Jane will hand me a note and say, you need to talk to number 12, number 14, number 22, number 28. We haven't heard from them. Because when you're up doing voir dire, you're on a roll, but you can't keep up with all of those details. And so I think things like that are really important, that you're comfortable in the room. You're comfortable just doing your regular stuff and talking to your jury consultant without being embarrassed about it and letting them know what you're doing. Now, I don't tell them she's a jury consultant, that she's a PhD psychologist. I just say she's there to help me pick the jury, and her name is Jane.
Got it. How about, but we didn't, the comparative fault aspect, because that was is that something you talked about in the Greyhound case? Because it seemed like
absolutely
type of case.
Absolutely. I talked about, chasing a moving vehicle. Now, the judge wouldn't let me go into specific facts too much, so I had to kind of skate over it. I can't remember. It was really delicate the way I handled it, and quite frankly, I can't remember exactly what I said. But talk to people in generally about that. But I had, by the time we got that case ready for trial, I was convinced that people would think they would run after a bus if they were being left. You don't think this is dangerous. You think, I got to get on the bus. One thing that happened in that case is she was a supervisor, and Jane Paulson, the lawyer that brought me in, we hired an investigator to find the other passengers on the bus. And it was a tough job. And we found 4 or 5 of them. I don't mean this snotty, but usually it's lower income people that travel on these buses. So it was quite difficult.
I don't think you're being snotty. I'm not sure that too many people listening to this have taken a cross-country bus trip on a Greyhound. At least
I'm always real conscious about coming across that way, But anyway, so we had to find these people, and it was amazing the testimony that we got from them. That, we were all screaming at him to stop. It scared us. We couldn't believe it. Then we found a supervisor through the document production who, about 2 months before, had been traveling with her sister somewhere with this same driver, Mr. Colby. He was a jerk. And traveling with him. And her sister got off at a bus station at a truck stop, and he started pulling out and left her sister behind. This supervisor sent an email to the upper management at Greyhound and said, "This man is a danger for our company. He does not put the passengers first." I mean, we had some real dynamic stuff that came out during discovery in that case. That was kind of, I don't know where I got off on that, but it was, it was fun.
I was talking about comparative fault here.
I guess what I'm saying, we got so much bad evidence. I think by that time the jury's like, we just want to roast them, man. They were doing this. They should have pulled him off. Another thing that happened in the case, you won't believe this, they didn't fire this driver after he killed my client. They waited like 2 years, because it was 3 years after the death that we tried it. And he had thrown another passenger's cell phone, and that got him fired. I kid you not. You can kill somebody, and that's not going to get you fired, but don't be jacking with somebody's cell phone. We had fun with that one in trial.
I imagine you did. I
love trying cases.
I
so
know, I can tell. That's why you keep doing it and do it with a lot of passion. And you said you just got one coming up for trial in 2 weeks, but so this with Brent Godarzi, and where's that at? Brent Godarzi?
This one, that's in Dallas County. It is a trucking accident case. I've tried some motor vehicle accident cases. I don't think I've ever tried a trucking accident case, so this is going to be a new experience for me. But, when people say, do you want to go try a case with me, it's really hard for me to say no, because I love doing it so much.
And it's going to be on Court Review Network, so
it is.
You can tune in. And so was your last verdict for the $72 million.
And I've never watched myself on Court Review Network, and I never will.
Yes, you did.
Except when you made me a little bit.
I made you watch a little bit.
You made me.
Okay, we're always getting better, Charlie. It doesn't matter how big our verdicts are. We always got to keep.
Oh, no. I just don't like watching myself. I hate it.
Oh, I know, but when you watch yourself, you get better. Just like I listen to these podcasts as soon as they come out, because I'm trying to become a better host. Because I think everybody's
okay. You're teaching me, Dan. I need to go watch it. I'll do it.
You want to get better.
I'll try to make myself.
You want to always. That way it's more funny for always improving too. I think. This game called
Absolutely.
Life or Profession, or trying cases, or hosting podcasts or webinars. It took me a while to figure out how to be a better webinar host, and I'm still working on it. And the culmination of all my skills will be showing off on September 4th when I host your webinar. So you see,
I'm excited. I think it'll be fun.
It will be. It will. I'm stoked for it too. But opening statement in the Greyhound case. Tell us about your philosophy approaching opening, and especially talking things about visual strategy, because I see a lot of people use a lot of visuals these days, and so give us some of your thoughts on opening and the Greyhound.
I'll tell you, it's been a long time since I've done an opening statement, because I'm usually trying cases with younger lawyers, and I like for them to get experience, and they usually do the opening statement. I may be wrong on this, but I always think that's not going to be outcome determinative, and it's a great learning tool, and we usually go through it. But if I were doing an opening statement, and understand this, I'm not real big on technology. One thing, because I'm technologically challenged, but I don't like lots of words and PowerPoints in opening. I really don't. I think it's the time to connect with the people. And I firmly believe that opening should be about the bad conduct of the defendant and not about your client. Obviously, you have to mention your client, but I don't think it should be arguing damages. I never do that, or never let anybody that's trying a case with me argue damages in opening statement. I think it's about telling a story. This is a story about, and go through it. Now, we oftentimes will use slides of evidence that shows things. What the case that we just tried, which is a workplace injury, the whole accident was caught on video, and we made the decision to show a portion of that video in opening statement because it was just so powerful. But the downside is if you show too much, it desensitizes the jury to the tragedy that you're looking at. I do not normally use depot clips in opening statement. I just think you need to save some of that fun stuff, because trials can get boring, and if the jury's bored, that's a really bad thing. And so I usually save the really powerful stuff for the trial rather than opening statement. I don't think they should be too long. I think you should keep them pretty brief and hit the high points and be done.
In your upcoming trial, since you usually say you let the young lawyers do it, you're going to let Brent do the opening statement in your trucking case, since he's a little younger lawyer?
Brent Godarzi?
Yeah,
He is younger than
I
me,
know.
actually.
So you can let him do the opening.
We have not even gotten to that stage yet. I just made an appearance in the case last week, and I'm reading depositions, and then we're going to meet and decide the breakup of duties.
All right. Well, I'm looking.
Hey, but I'm a great second chair. I think we'll see after 2 weeks.
It's been a while since you've been.
It's been a long. I can't remember that. I don't think I've ever been a second chair. I didn't have mentors.
Nobody, not a lot of people do. I mean, that's that's why, I started Trial Lawyers University during the pandemic, because unless you work with, a Brian Panish or, your Caleb or your Eleanor, your daughter and associate that work for you, there's not a whole lot of mentoring going on in this world, just the nature of the beast, and there's not as many trials. And so the opportunity to get mentored and learn, I think, is just probably not. Well, I think it's not the same, but I still think people say it doesn't exist. I disagree. I think there's so much opportunities to learn because, everything we do on these webinars and everything we do at these live conferences is all recorded and put on TLU On Demand, which is an app for your phone. You can watch it on the computer, and I collect all the pleadings, transcripts, and PowerPoints for all of these cases. So it's such a great, roadmap for trial. I was talking with somebody yesterday. They're like, it's like the Bible for trial. I'm like, that's a good analogy. It's like a Bible for a trial because there's just so much stuff that you can learn from anytime. That didn't exist 4 years ago. So I think there's
That's why I'm here, because Caleb and Eleanor said, man, we've been listening to these great podcasts and webinars for Trial Lawyers University. Have you heard of it? And here I am.
Well, I'm just saying, see, now you're helping mentor the future generations besides, Caleb and Eleanor. And so let's move on to order of proof, though, and how you think about it. I know you told us you started off with the Greyhound rep, but just kind of give us your thought process when you're thinking about sequencing witnesses and the evidence.
It usually, it always does boil down to the case, but I normally call an adverse witness as my first witness. But the first thing I do is call Mark Mandel, who wrote the book on case framing, and talk to him about framing a case, and he's always so helpful on that. But yeah, I usually always call. I can't remember the last time I have not called a corporate rep or some member of the defendant's organization as my first witness.
Well, let me ask you, since you like Mark Mandel, I know he's an inner circle friend of yours, and he wrote the book on case framing on trial guides. And so this Greyhound case, when you call him up, give us just some insights on the conversation about framing this Greyhound case.
His was do your job, because we showed that the driver did not do his job. He did not do a head count. He left a minute before he was supposed to. There were like 5 different things that he did not do that he should have done according to Greyhound's on policies and procedures. So it was do your job. If you don't, it's inevitable that something bad, including death, can happen. And that sounds so simple, but if that's the theme all the way through it, and Mark talks about having, I just can't get over it. It's your 5 best, I just can't get over it. It's like what the defense can't get over and then what you can't get over. What are your 5 worst facts? And to really narrow your case down like that. Because we can so often know the case so well that we get caught up in the minutia, and the jury's going to lose it. You gotta stick with, just the most important things. One other thing, I'll give you an example, Dan, that I think the viewers would find interesting on case framing. I was trying a dram shop case a couple of years ago. And I called Mark about it because I was representing a Dallas Cowboy, the family of a Dallas Cowboy that was killed when his best friend, who was also a Dallas Cowboy player, wrecked a car, and he was drunk, and we were suing the bar where he got the alcohol. We had a video of him at the bar, and he did not look intoxicated. And the standard in Texas is you have to serve someone that is obviously intoxicated in order to show that the bar is liable. So that was our problem. However, the single car accident, happened 6 minutes after he left the bar. And the police officer in his deposition testified that if this driver had tried to leave the scene, he would have arrested him because he was so obviously intoxicated. So then, despite how he looked at the bar, if the police officer believed he was so obviously intoxicated, he had to have some appearance of obvious intoxication at the bar. Mark helped me frame that case I called the police officer in that case as my first witness, which was a brilliant move. I would not have done that because I would normally you started, drinking, doing this, going through the sequential chronological events. But no, we started with the police officer. This guy was so dog-ass drunk that you would not have let him leave the scene of the accident. Yes. Well, then the jury's going to think, how in the world can he not be that drunk 6 minutes before? That's what I'm talking about on not just case framing on do your job or inevitability. It's the way you put the evidence on and the chronological order in which you do it. So that's just one example of how I didn't call an adverse witness that time. I called somebody to set the stage for obvious intoxication. So it obviously varies from case to case, but by and large, I try to call someone adversely in my case in chief. It just makes it more exciting, you know. Juries like to have exciting. But I will say this to the female jurors here, and I love mentoring young women. As women, and it's not nearly as bad as it was 37 years ago when I started, but as women, we have to still earn the right to be overtly aggressive. Jurors expect it of men. They do. They do not expect it of women. You're called the B word, or you're too strident, or you're too emotional, or you're too blah, 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 blah. I hate it that it's that way, but it is the truth. So I always challenge young women that I'm mentoring is remember, you got to start easy. When you call the corporate rep, you can't just hit him over the head like men could do. Start easy, let the jury get mad first, and then you get aggressive and mad. Then they love it.
All right. So if you start off with that, but like the Greyhound case, so I think about the sequencing of witnesses. So we call the first person you said was the company rep?
He was the corporate rep and also the director of safety. I had deposed him, and we called him as our first witness.
Okay, then
adversely.
After that, when did you call the driver?
Could not call the driver because he was outside of subpoena range and he was no longer employed by Greyhound. So I had to take a trial deposition of him the first time, but he came across as the biggest jerk in the world and did not play well with the jury. We actually flew in two of the witnesses because they were such powerful witnesses. And we told the jury up front, we're paying for them to come. We're paying their airfare because they can't afford it because we think you need to hear from them in person. And I usually call my client, no matter what kind of case it is. If it's more than one client, I don't like to put them one right after the other, but I usually try to call them towards the end of the case. And in the Greyhound case, we called the mom as the last witness, and she was an absolutely powerful, powerful witness.
I bet. So moving from your case, so the Greyhound's case, who did they try to put up to try to justify their actions and minimize their
They called
exposure?
as I recall, it was and I need to look at this before we do our webinar, look at it more closely because it's been a minute since I tried it. But they called a bus driver policies and procedures person who say that you have to stay on a schedule, you have to adhere to rules, that sometimes passengers are not going to comply with the orders they're given, blah, blah, blah. They called, as I recall, a medical expert to say that Hunter did not have conscious pain and suffering given the way he died, which I thought was a really stupid thing to do because then you go into graphic detail about how he died.
I mean, that must have been,
they call?
I guess, not fun, but like in a odd, in like a dark sense, like fun. Like, let me show you like about the pain and suffering. Let me just drive this home through.
It was like, and part of you wanted to go over and hug the defense lawyer and say thank you, but I made sure the parents left the courtroom. We were going over that. And, honestly, Dan, right now, I can't remember who else they put on. The case lasted for about 2.5 weeks, so they must have called more people. But we ended up got a high-low in that case while the jury was out, by the way.
Really? So why did that negotiation, how did that negotiation come up? Or that discussion come up?
They had not offered much of anything. And like I said, you can't fall in the basement, so we were ready to try it. And my clients didn't desperately need the money. But we were giving them a pretty good licking through the course of the trial. And there was an insurance adjuster that was there in the courtroom, and I think a monitoring counsel, if I recall. And so they started approaching me. And while the jury was deliberating, I talked to Paula and Barrett at length about it and said, look, if this case goes in appeal, it's going to be 4 or 5 years. This is totally your decision. I think we're doing well, but I've never had a case yet I couldn't lose, the whole spiel that you always give to clients. And they made such a good deal for us, the Greyhound folks. I can't say the amount, but we came out, it was a good settlement. And it gave finality to the parents.
Wow.
I normally don't like high-lows because I'm so mad by the time I get to that stage. I'm like, screw it, I'm going for a verdict. But you never know what an appellate court's going to do. So especially in Texas with the lovely Texas Supreme Court that we have. So it was a good outcome for my clients in that case.
And just like the high-low down in Orange County, because in that case where John Campbell, you did
Exactly.
get defense. So
I did that because John Campbell told me
I
I better
know,
settle the case.
I know, because I heard you guys got defense. I'm like, that sucks. And they got a high-low. I'm like, that's
I, I,
brilliant.
I'll tell you what happened in that case. This is a really funny story. Dana Fox was defending the case,
Oh yeah, he's
and
Brian Panish's best friend, Dana Fox. He just loves going to
yeah,
trial
yeah,
with him.
they have a love-hate relationship. Sometimes they like each other, and sometimes they don't. I actually didn't have a problem with Dana. He's just too perky. He's always so excited. I'm like, have a bad day and get back with me. But he and I ended up doing the negotiations. So we were going 2 tracks of negotiations. One was a direct settlement, and one was a high-low. The problem is our client believed that God was telling her whether she should settle the case or not, and God was telling her not to settle the case. Well, it's hard to argue with God. So I didn't tell Dana that. I just kept negotiating, thinking, well, God's going to be talking to me before it's over with, and then I'm going to tell her God talked to me louder than he talked to you. So we were negotiating on these 2 tracks. The jury asked a question to let us know it was a clear signal they were still on liability. And our group was in one end of the hall, and Dana's was like 5 doors down the hall of the Orange County Courthouse. And the bailiff came in and knocked on our door and said, we have a verdict. Well, I knew immediately we lost. So I go hauling down running ahead of the bailiff. I knocked on Dana's door and I said, we accept. And he goes, which one? I said, I don't know yet, but we do accept. And I went back to our room and I told our client, I said, God talked directly to me. So I had to go down there and get this done. I want you to know I just settled your case. She goes, okay, praise the Lord. I'm glad. And we ended up having the high-low settlement. That was some levity during a very, very stressful time.
It's hard when God interferes, because like I was doing a criminal case once with my buddy back in like 2005. He was my roommate from the trial, or buddy from the trial lawyers college. It was a drug case up in Santa Barbara, and this guy got caught with the drugs right outside of his door or something like that. And there was this big surveillance. It looked like a real strong case, so we like negotiated a pretty decent deal. And I said to my buddy, is this guy taking the deal? Because I was just doing it volunteer and just help my buddy out. So I'm like happy to get rid of the case. And he's like, no. I'm like, no. He's like, God told him that he can't do this. He's innocent. I said, well, because I'm just like, well, I hope God's going to be in that courtroom because we're going to need him with this case.
Hope he's talking to the jury as well.
I was just hoping he's with us. But it was crazy because God was with us, because it was the craziest case that the jury came back with a hung jury, because we came up with this story that the police had actually framed them because they didn't videotape or record anything they did. It was all just their word. You just expect to take your word, and there was a hung jury, and they ended up getting like a misdemeanor after that. It really worked out well. God did interfere on his behalf.
God was talking to him.
It was crazy what a difficult case it was. And
you know what I wish, Dan? I wish 37 years ago I had kept a book about funny things that have happened in trials. I mean, because it's just stuff you just can't make it up. It's just the best in the world, some of the things that happen. It's good, though, with all the pressure, that you have during trial, that you get some levity and some funny memories.
Yes, and and it's so much fun when you try a case with like a friend, and so you're just like having this creative process of like 3-dimensional chess is really what it is. But
it is.
And,
it's fun.
There is a game and competitive element to it. It's not. I mean, I realize we're doing very, very important work, but the competitive nature of it is, I think, what drives most trial lawyers to get to the top is the thrill of the competition.
Exactly. It absolutely is. We don't like to lose. And I don't like bullies.
Right. Those bullies, they got to be put in their place.
Absolutely.
Let's talk about closing argument and, empowering the jury and getting the money. So, or telling them what the value is, I should say.
People have often asked me, when do you rehearse your closing? I've never rehearsed a closing in my life. I don't write out closings. I probably should. I'd probably be a better lawyer if I did. It's just not in my gut. I usually have an outline of what I'm going to do and get up there and do it with sincerity and emotion. Gosh, it just depends on the case, which way, how you actually argue a closing argument. But I think empowering the jury is very, very, very important, because that's the point where you want them to know that they are the last stand that you have, that you've done everything you can. Many times I will say, I've been fighting this fight to get this company to do the right thing, to admit that they did wrong, to admit that they're responsible, and to have some accountability for 4 years now. And I got to tell you, Right now, I have mixed emotions because I'm about to give that burden to you. I'm scared because I'm afraid there's something I have not done that I should have done to show you the truth. But I can tell you I've done the very best. I fought with my heart, my soul, and everything I had. And I'm going to now give this burden to you. And you now can do what I have been unsuccessful in doing. And that is to tell Greyhound bus lines, you cannot allow drivers to act recklessly. You cannot allow drivers to act in a manner that threatens people's lives. We will not accept it.
But in this case, the Greyhound case, because the framing articulation of the damages. So how did you talk about damages in this closing argument?
I said, I talked to you a little bit about drug addiction in our society, and I'll have to go back and look at. Well, I don't have any notes, but
Yeah, just
let me just say what I would say if I were doing it right now.
The exact words are not. We're not looking at transcripts here, Charlie. Just
Okay. This case is one of the saddest cases I've ever seen because there is a life that's lost, and any time a life is lost unnecessarily, it's horrible. And there is a word for us if we lose our spouse. We're a widow or widower. There's a word even for us if we lose a parent. Both of our parents were an orphan, but there is not a word in the English language that can tell what Paula and Barry are right now, because we should never have to bury our children. Now, the defense would have you believe that it's not that big a loss because their child had an addiction. He had been kicked out of the house. They had been estranged for many years. They would have you believe that, and that is absolutely disgusting because we love our children unconditionally. And these two people right here loved their son unconditionally. And even go into the fact that I think I mentioned this earlier, Dan, that to lose a son who you've been estranged from because of their addiction, and then this child eventually say, I want to get help for the first time, saying, Mom and Dad, will you help me? I want to go to rehab on my own volition. And to have sent him off in that moment of hope and to have lost him before that reconciliation could take place, they will never have the healing that they deserve. We went into the damages for Hunter Brown. Yeah, he was high, but people had been talking to him. He was cognizant. He was holding conversations. He was reading on the bus. He was running after that bus, desperate to get back on so he could get to a place to heal. And he knew the moment that wheel caught his foot that he was going to die, and was going to die at a point in his life where he knew he had disappointed his parents for all those years. Things like that. And then what I usually do on damages, I always put the jury charge under the Elmo with a red Sharpie and answer the questions. I go through them and write out yes, no percentages and everything. And I know in that case with Hunter, I said, if you think there's any negligence at all, it is a very small amount. And we argued 10%, and that's what the jury put on him. But when it comes to damages, I usually give a range and, say, because I still hate these words, what sum of money if paid now in cash. It's such a cold thing to say when you're talking about the loss of life. But that's all we can do. And then say, I'm not the one to tell you exactly what that amount to be, but I think the evidence shows, and I give a range like 5 to 7 million. And we have multiple blanks in Texas, and I go through every one of them and write out what is, what I think is the range that they should give.
All right. And so in this case with the Greyhound, just give us an idea. What did the defense argue?
It was funny. I knew that the lawyer, he's a very good lawyer, but I knew what his argument was fair and reasonable, fair and reasonable, fair and reasonable, fair and reasonable. One thing, I just remember this, that he did that I thought was so incredibly offensive, is he asked them, I can't remember the amount of money, it was like 100,000, maybe 200,000, something like that. He asked them to give the mother more than the dad because she obviously was more sad about the death of their child. You think I didn't have fun with that in closing? I kid you not. In rebuttal, yeah. Oh my God! I when he said that, I almost fell off of my chair.
So what'd you say in rebuttal?
She cried more, so she misses her child more. She had more mental anguish. But he did fair and reasonable. But I knew he was going to do fair and reasonable, so I couched a lot of my questions as fair and reasonable, like with the corporate rep. Now let's talk about what is fair and reasonable in an investigation such as this. Let's talk about what's fair and reasonable with a driver and their actions with regard to passengers. So as I recall, the lawyer, he did a lot of the fair and reasonable, that this is not winning the lottery, the blah, 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 all the same stuff. They argued no negligence, but then they argued for a few $100,000 in compensatory damage or in mental anguish damages.
So they were a little bit off, is what you're saying.
No, yeah. I mean, things like that, you're like, how can somebody stand up with a clear, just to say that the mother suffered more than the dad? And after we visited with the jury afterwards, they were quite offended by that comment. They gave the parents the same amount.
It's so many cases that I've seen or involved with or consulted on. It seems like so much of the damages is driven by the defense counsel conduct.
It really is. And this guy was not one that ticks off a jury. He wasn't, like, I love it when I get assholes on the other side. It makes it so much more fun. This guy was not. He's not a jerk, and he didn't come across that way. But he made that one argument, which was so incredibly stupid. And it made him look cold-hearted. And another thing he did, there's another thing he did was really stupid, is cross-examining the mother about her book, The House Built on Stilts, and how she talked about losing her child. Like he said, isn't it a fact you lost your son many years before this death? I mean, he just set her up to just absolutely take his head off. And she did. She was a very articulate witness, and she let him have it. And I do believe things like that increase the value of the case, no question.
No question about it. Well, Charla, this is coming to an end now, but one of your friends is coming to Las Vegas without you, and she's part of your group called, is it Athea? Is that
Athea? Yes.
So Randy McGinn is coming and teaching a few hours in a workshop. We're very excited about it.
She's my sister. I love her. She's getting married in August.
Well, isn't that exciting? Maybe she'll bring her new husband with her to Las Vegas.
She probably will.
It's a great place for young couples to celebrate their new marriages together. So it's going to be great. And hopefully your partner and Caleb will be in Vegas visiting us in October at Caesar's Palace. It's going to be super fun. We should have about 1,500 people, and we're going to have nine lecture tracks and 20 workshop tracks. So there'll be a lot of organization over the next 106 days, but we're all fired up, and I'm really looking forward to it. It's been great getting to know you, Charla, a little bit more, and we'll see you on September 4th, and we got some preparation to do before then, and I'm looking forward to watching your trial in a couple weeks, and I'm hoping to see you do the opening statement that you are excited about.
You're going to see me actually do it.
We'll
I
see.
love it. Okay, Dan, I'm sorry I can't be there in Las Vegas, but I am committed to Huntington Beach. I will be there.
Perfect. Well, you have a great day, and thanks for visiting. Take care.
Okay, thank you, Dan, very much.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.